Hello friends, very warm welcome to my business laws channel. Last time friends, I had started, I took up the heading fraud, misrepresentation and the difference between fraud and misrepresentation. Then can silence be taken as fraud? So this will be the last lecture to the chapter free consent. In this lecture, I'm going to take up exceptions to the right of rescission of the contract. And then after that, I'll take up mistake, what is mistake and what are the types of mistake. Loss of right of rescission. You all know friends, when we talk about wordable contract, the consequence of wordable contract is the party has two options to exercise. One is affirmation and second is right to put an end to the contract, which is also known as cancellation and which is also known as rescission of the contract. But there are certain cases when this right of rescission is lost. So broadly speaking, there are 4 points. First is affirmation of contract, the lapse of reasonable time, rights acquired by the third party, restoration of the parties to the original position. Now, all the points I'll explain with the help of examples. The first one is affirmation of contract. When a party, after becoming aware of his right to cancel, affirms a contract, either expressly or impliedly, then he loses his right to rescind the contract. So you all know friends, affirmation, when we talk about it, may be express or implied. Express means it is verbal or written. Implied is neither verbal nor written, but inferred from the circumstances of the case or from the conduct of the parties. Now, example is before you. X fraudulently sold his motorbike to Y in the month of June. Y, after becoming aware of the fraud, affirms the contract. Now, once the injured party, aggrieved party has affirmed the contract, subsequently, that party will not have the right to put an end to the contract. So his right to put an end to the contract will be lost in case of affirmation. Second is lapse of reasonable time. Continuing with the same example, once the reasonable time is over, then also the party has no right to put an end to the contract. So continuing with the same example, the motorbike was sold in the month of June, but Y wants to rescind the contract in November. So July, August, September, October, after 5 months, then we will say the time is over now. Because the time is over, reasonable time is over. As far as reasonable time is concerned, friends, the ICA is silent about this. It depends upon the circumstances of each particular case. So once the time is over, then the party is bound to affirm the contract. The party's right to cancel the contract is lost. The case law is here. I would like to take up this case law, which is Jagannath Prasad versus Allahabad. Now, prospectus of a company contains some false statements. On the faith of these, a purchase of shares in July. So shares were purchased in the month of July, but he wants to set aside the contract in December. So there is time lag or gap between the 2 months. Okay, so here unexplained delay of 5 months was unreasonable. Therefore, he was not entitled to cancel the contract because the time was over. Now, third point is rights acquired by the third party. If under the wordable contract, the person is in possession of goods and the rights have been acquired by the third party, then also the injured party is bound to affirm the contract, has no right to cancel the contract. In the given example, I will like to continue with the same example. Y, after becoming aware of the fraud, further sells the motorbike to Z, who buys in good faith and for value. He has paid the consideration and is unaware of this fact that Y has obtained X consent at gunpoint. or he has obtained his consent is caused by one of the four factors. After the title has passed to Z, Y loses his right to cancel the contract. Restoration of the parties to the original position. Now the situation is such that parties cannot be put or cannot be restored in the original position. Now I have taken the example of motorbike. When the motorbike is in the possession of Y person and Y is possessing this motorbike under wordable contract. See, unfortunately, bike gets destroyed in an accident. Then also his right to put an end to the contract will be lost, because the item which is not in the existence, nobody would like to accept this damaged motorbike. So friends, here the wise person, ex-person, the owner of the motorbike will not have the right to put an end to the contract. So friend, this is all about these four cases. Now I'll take up new heading, which is mistake. Now what is mistake? Mistake may be defined as innocent and erroneous belief which leads the party to misunderstand the other. There is misunderstanding in case of mistake. Now example is A agrees to sell to B a specific cargo of goods supposed to be on its way for England to Mumbai. It turns out that before the day of the bargain, the ship carrying the cargo had been passed away and the goods lost. Neither of the party was aware of these facts. The agreement was void. Both the parties must be under a mistake. So this is a case of mutual mistake. So the agreement will be void. Now coming to the classification of mistake or types of mistake. Broadly speaking, friends, mistake we can put under two categories. One is mistake of fact and second is mistake of law. And sections here are sections 20 to 22. So bilateral mistake of fact can be classified under two heads. One is bilateral mistake, second is unilateral mistake. Now bilateral mistake can be of two types. One is as to subject matter, second is as to possibility of performance. Now unilateral mistake again can be of two types. One is nature of transaction, second is identity of person. Now subject matter may pertain to 6 types. Bilateral mistake as to existence, bilateral mistake as to identity, bilateral mistake as to price, bilateral mistake as to title, bilateral mistake as to quality, and bilateral mistake as to quantity of goods. Now coming to the mistake of law, which can again be put under two categories. One is law of land and second is foreign law. So friends, I'll explain. Everybody should know the law of one's own country. Mistake as to Indian law is not excusable. Anybody who is citizen of India must know the law of his own country. He cannot travel without ticket in the bus. He cannot jump the red lights. He cannot commit the murder. Murder commission is not permitted. He jumps a red light. When he's caught, he says, no, I was not aware of this law. Nothing doing. He will not get any excuse. Ignorance of the law of one's own country is not given any excuse. But ignorance of the law of other countries, that is excusable. No person, we cannot expect from anyone, apart from knowing the law of his own country, he should know the law of other countries too. And now friends, I would like to explain types of bilateral mistake and then unilateral mistake. Now mistake of fact, I have told you it may be of two types. One is bilateral and second is unilateral. Now what is bilateral mistake? According to section 20, where both the parties to the agreement are under mistake as to a matter of fact essential to the agreement, Now that is called as bilateral mistake. But there are some conditions which have been laid down under section 20 which must be satisfied. Now, which are these conditions? First is both the parties must be under a mistake. Second is the mistake must relate to the mistake of fact. And third is mistake must be mistake of fact and not mistake of law. Now, there is a case law regarding this, Galloway versus Galloway. A and B entered into a separation agreement which provided that A was to pay rupees 15,000 to B. Subsequently, it was discovered that they were not legally married. When they were not legally married, then the question of payment does not arise. So B sued A to recover the agreement. It was held in the court of law that B could not recover amount, the agreement being void. In this case, both the parties were under mistake of fact, which was essential to the agreement. Now, bilateral mistake, as I have told you earlier also in my lecture class in the beginning, bilateral mistake can be of two types. One is mistake as to subject matter of contract, and second is mistake as to the possibility of performance. Now, mistake as to subject matter of the contract can be of 6 types. All 6 types I have given you. Now I'll explain all the points one by one. The first one is before you, which is mistake relating to the existence of the subject matter. Both the parties were under mistake as to the existence of subject matter. The item did not exist, but it was not known to the parties. A agrees to sell his motorbike to B. Okay, and now the agreement takes place on 1st of July. And the motorbike is to be delivered on 5th of July. But at the time of delivery, both the parties come to know that motor had already been destroyed in an accident which took place on 28th of June. But this fact was not known to both the parties. So motorbike did not exist. So there was a mutual mistake as to existence of subject matter. Coming to the second point, which is mistake relating to the identity of the subject matter. So you all know, friends, that there must be consensus ad idem between the parties. If there is no consensus ad idem, both the parties are not agreeing upon the same thing in the same sense, then that agreement will not be valid. It will be void. A has 2 cars. One is Honda City, other is Wagoner. He wants to sell Honda City car to B, but B is thinking of buying his Wagoner car. So there is no consensus ad idem between the parties, or we can say there is mistake as to identity of the subject matter. Then mistake related to the price of subject matter. So there is a case law regarding this, which is Lakshman, Prasad and Sons versus Achoothan. Now, in this case, there was a dealer of Honda City cars. He sold one car to N for rupees 8 lakhs on the belief that it was controlled price. N paid the price, believing it to be the controlled price. In fact, the controlled price was rupees 7,50,000. N was entitled. So control price was less than the price which was paid by him. So in this case, N was entitled to recover excessive amount of rupees 50,000 which had been paid by him under a mistake of fact. So next is mistake related to the title or ownership of the subject matter. So Nemo that quod non habet, non-owner cannot make a valid sale. If the sale is made by non-owner, then the agreement will not be valid. There is a case law regarding this, which is Cooper versus Phibbs. In this case, A agreed to take a fishery on lease basis from B. Both of them believed that B was the owner. But later on, it was discovered that fishery in fact belonged to A. So both were under mistake. A was thinking B is the owner, B was thinking A is the owner. So the agreement was held as void. Mistake relating to the quality of subject matter. Here, there's a mistake as to quality of subject matter. A agreed to sell to B a piece of original painting of famous artist M. Hussain, which was lying in his gallery. B paid a very high price for the painting. A thief had stolen the original painting and replaced a copy, but this fact was not known to both the parties. So, subsequently, B discovered that it was not original painting. So, friends, regarding this stealing of the painting, nobody knew, nobody was aware. Here, it was held in the court of law. The agreement is void as both the parties are mistaken as to quality of the subject matter, and subject matter was painting. Mistake relating to quantity of subject matter. The case law is Ernest Beck and Company versus K.S. Ovsky and Company. A agreed to buy 100 sewing cotton reels from B. Both the parties believed that each reel contains 200 meters of thread. This was the length in the reel. Actually, the length of the thread per reel was much less than 200 meters. So in this case, friends, it is very clear there was a mistake as to quantity of subject matter. Now, mistake as to the possibility of performance. Now, first mistake I have completed. Mistake as to subject matter, which can be of 6 types. I've explained with the help of example. I hope you all must have understood all the points. Moving ahead, now second is mistake as to possibility of performance. Both the parties believe the existence of the certain circumstances is necessary for the performance of the contract, and it is not capable of being performed in their absence. So the contract is void. Now, type of impossibility. Now, when we talk about impossibility, it may be of 2 types. One is physical, second is legal impossibility. What is physical impossibility? That is, that item does not exist. A agrees to hire B's hall to witness procession to be held on 26th of March. Unknown to both the parties, the procession had already been cancelled on 24th of March. So once the procession is cancelled, then the requirement of hall is not there. So the agreement will be void. Legal impossibility, if the law does not permit for the performance of the act, the agreement is void. A agrees to sell 100 bags of cement to B on 20th of January. But on 15th of January, the government bans the sale of cement in the open market. The agreement is void. Any change in the government policy, any change in the law after the agreement of contract will transform the valid contract into void. So there is legal impossibility. So performance of this agreement is not possible. Unilateral mistake. Till now, I have explained bilateral mistake with the help of case laws and examples. And now, friends, I will take up second type of mistake, which is unilateral mistake. The term unilateral mistake means that one of the parties to the contract is under mistake. Remember, friends, Section 22 lays down that here one person is under mistake, not both the parties. If one person is under mistake, then the agreement will not be void, it will be valid. The unilateral mistake does not affect the validity of the contract unless it relates to some fundamental fact that the other party is aware of the mistake. A person under bilateral mistake cannot take the advantage of his own mistake. So this can be of 2 types. One is nature of transaction or document. Second is identity of person. Now, before I take up this point, I would like to explain that unilateral mistake. Now, friends, say A agrees to sell painting to B. He says painting is duplicate, but B is thinking that painting is original. The price of the painting is 20,000 rupees. So A never told B that painting is original. But B is thinking that painting is duplicate, painting is original. So he pays a price and now he takes the painting, possession of the painting. He goes and consults his friends and find out that painting is original or not. His friends tells him that painting is duplicate. Now he wants to return this painting to the seller. He cannot return, friends, because seller never told him that painting is original. He was under mistake. So whenever one person is under mistake, then the contract will not be void, it will be valid. So in this example, buyer will not have any right to return that painting to the seller and get back his price. And now, friends, but there are two cases where the agreement is void ab initio. The first point is before you, which is nature of transaction or document. When a person contracts in a mistaken belief that he is signing different types of document because the true nature of the document is not revealed to him, then the agreement will be void. It will be void ab initio. The important case law is Raja Singh versus Cheku Singh. R, aged 70 years, was unable to manage his cultivation and his affairs. He appointed C to look after his cultivation and his affairs. C asked R to grant him a lease of the land. R agreed to this and placed his thumb impression on the deed, which was in fact a deed of land. It was a gift of land, but he was told that this is a lease of his land, but it was in fact a gift of land, held the deed was void ab initio. In this case, R was under mistake as to the true nature of the document. So friends, here the agreement was not valid. Now, identity of the person, where identity of the person is important, and the person is under mistake as to identity of the person contracted with, then the agreement will be void. So friends, there is an important case law regarding this, which is Sad versus Butt. Sad was regular critique of all the plays of the theatre company. We, the managing director of theatre company, gave instructions that no ticket were to be sold to S for the performance play at the theatre. S knew this fact. He was aware of the fact. Therefore, he sent one of his friends to obtain a ticket for him. He was, however, refused entry into the theatre. S sued for the breach of the contract. It was held in the court of law that there was no contract, as the theatre company never intended to enter into the contract with S. Because in this particular case law, there was a mistake as to identity of the person contracted with. Because theatre company never wanted to enter into a contract with S person. Sad. So it is all about the entire classification of mistake. And this is all from my side. I hope you must have understood all the concepts and you will definitely like this content. Do like my channel, do subscribe to my channel and press on the notification so that you can get notifications of my subsequent videos. Friends, keep smiling always and stay happy always. Okay, friends, be blessed always. Goodbye. We'll meet soon. Bye-bye. Bye-bye. Bye-bye.